Business law, partnership, part 1. Definition and concept. Partnership is a contract whereby two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. A partnership may also be formed for exercise of a profession. Partnership is an artificial being created by agreement of the parties with personality separate and distinct from that each of the partners. Hence, if A, B, C, and D form Sunrise Company, the individual liabilities of the partnership cannot be surcharged against the... There are now 5 persons, namely A, B, C, and D, and Sunrise Company. The individual liabilities of the partners cannot be charged against the partnership, and the liabilities of the partnership are not chargeable against the partners, unless the partnership assets have already been exhausted, in which case the separate properties of a general partners shall be liable for the satisfaction of partnership liabilities to third persons. Sharing of the gross returns does not of itself establish a partnership, because in a partnership, the partners share in profits. When a person receives a share in the profits of business, there is a presumption that he is a partner in a business, except if the share in the profits represents payment of a debt or by installment or otherwise of his wage as an employee, for the rent of his property, for annuity as a widow or representative of a deceased partner, for interest on loan, and as consideration for the sale of goodwill or other property by installments or otherwise. Essential requisites. There must be a valid contract. There must be a mutual contribution of money or property or industry to a common fund. There must be an intent to engage in lawful business, trade, or profession. The purpose is to obtain profits and divide the same among themselves. The objective or purpose must be lawful, and there must be 2 or more persons who have legal capacity to enter into contract. Characteristics of partnership: consensual, nominate, bilateral, principal, preparatory. Distinguished from corporation. Partnership is created by contract, corporate created by operations of law. Partnership may exist indefinitely. Corporate may exist for not more than 50 years. Partnership managed by all partners if there is no managing partner. Corporation managed by the board of directors. Partnership general partners, a liability extends to his separate property. Corporation stockholders' liability is limited to his investments. Partnership may bind the partnership. Partners may bind the partnership. Stockholders cannot bind the corporation. Death of general partner in partnership dissolves the partnership. Death of a stockholder does not dissolve the corporation. And in partnership established by 2 or more persons, in corporation, incorporated by not less than 5 but not more than 15 incorporators. Partnership also differs from co-ownership, conjugal partnership of gains, joint venture, joint accounts, voluntary association, business trust, syndicate, and tenancy, in the sense that partnership has a separate juridical personality, while the others do not have separate juridical personality. Kinds of partnership. General partnership. 1 where all the partners are liable to the extent of their separate properties in case of the partnership assets are not sufficient to cover liabilities to third persons. Limited partnership. 1 which is composed of at least 1 general partner and at least 1 limited partner, the latter being liable only to the extent of his contribution. Partnership with a fixed term. 1 which has been agreed upon to exist only for a specific term or period or for accomplishment of a particular undertaking. Partnership at will. 1 whose period of existence has not been fixed by the parties. When the partnership with a fixed term or particular undertaking is continued after the termination of such term or particular undertaking without express agreement, it becomes a partnership at will, with the partners having the same rights and duties as before. Particular partnership. It is one which has for its object determinate things, their use of fruits, or a specific undertaking, or the exercise of a profession or vocation. Universal partnership may either be universal partnership of all present property or universal partnership of profits. Universal partnership of all present property is one in which the partners contribute to the common fund all properties which actually belong to them at the time of constitution of the partnership, as well as all the fruits of income of those properties. By stipulation, the fruits of the properties which the partner may acquire in the future may be contributed to the common fund, but the properties which the partners may acquire subsequently by inheritance, legally or donation cannot be included in their contributions. Universal partnership of profits comprises all the partners may acquire by their industry or work during the existence of the partnership. The properties of the partners at the time of the constitution of partnership still belongs to them, and only the usufruct passes to the partnership. If the articles of universal partnership does not specify its nature, the partnership is considered only as universal partnership of profits. Persons who are prohibited from giving each other donation or advantage cannot enter into a universal partnership. These persons are husband and wife during the marriage, persons who were guilty of adultery or concubinage in the time of the donation, persons found guilty of the same criminal offense in consideration thereof, public officer or his wife, descendants or ascendants by reason of his office. Partnership by estoppel is one which is not really a partnership, but because of the representation which had been relied upon by others, it is considered a partnership for the protection of third persons. De jure partnership is one which has been established strictly or substantially in accordance with the legal requirements. De facto partnership is one which is existing and operating as a partnership but suffers from some legal defects. Kinds of partnership. Partners are classified into general partnership, one whose separate property is liable for partnership liabilities once the partnership assets have been exhausted. Limited partner, one who contributes money or property to the common fund and is not liable for partnership liabilities beyond the amount of his contribution. He is also called a contributor. Capitalist partner, one who contributes money or property to the common fund. Industrial partner, one who contributes industry or personal services to the partnership. Industrial capitalist partner, one who contributes money or property to the common fund aside from his services. Managing partner, one who manages the business of the partnership. Liquidating partner, one who takes care of the dissolution of the partnership. Silent partner, one who takes no active part of the partnership business. Secret partner, one who is not known to third person as a partner. Dormant partner, one who does not take active part in the management of a partnership and it is not known to third persons as a partner. He is a secret and silent partner at the same time. Partner by estoppel or nominal partner. One is not really a partner but is considered liable as a partner for the protection of innocent third person. Subpartner is a third person whom partner has an agreement for sharing profit and losses. Substituted limited partner is a person admitted to all the rights of limited partner who has died or has assigned his interest in a partnership. Formalities of the contract. The contract of partnership may be oral or written, although the law, Article 1772, provides that a contract of partnership with a capital of 3,000 pesos or more in money or property must appear in a public instrument and must be registered with the Securities and Exchange Commission. Non-compliance with these requirements shall not affect the existence of its juridical personality and liability of the partners and partnership to third person. However, if a real party or real right is contributed to the partners, the law requires that the contract of partnership must be in public instrument and that the inventory of the same signed by parties must be attached to the contract. If the contract is merely oral, the contract is void between or among the partners. If it has been agreed that the obligations of the partners will be performed after more than 1 year, the contract of partnership should be in writing, otherwise the contract shall be unenforceable because of the statute of fraud also applies to partnership contracts. Contributions of the partners. The following are the allowable contributions of the partners. Capitalist partner, money or property. Capitalist industrial partner, money or property in industry. Industrial partner, personal services. Limited partner, money or property only. It is provided that if a limited partner shall take active part in the management of partnership business, he shall become liable as general partner, whose separate property shall be liable for partnership liabilities. The amount of the partners' contribution to the common fund depends upon their agreement. In the absence of agreement, the share of the capitalist partner in the partnership partnership capital should be equal. Share in profits and losses. The share of partners in profits and losses shall be based on their agreement, in case only the share in profits has been agreed upon. The partners' share in losses shall be in the same proportion. In the absence of agreement, their share in profits and losses shall be proportionate to their capital contributions. The industrial partner is entitled to a just and reasonable share in profits. If his share has not been stipulated, if an industrial partner contributed money or property in addition to his personal services, he is also entitled to a share in the profits based on his capital contribution plus the share based on the service rendered. An industrial partner is not liable for the losses of the partnership. The designation of the partner's share in profits and losses may be entrusted to a third person, but it cannot be entrusted to one of the partners. If the decision of a third person is manifestly unjust, the injured partner has a right to impugn the said decision before its implementation and within a period not exceeding 3 months from the time he had knowledge of the said decision. Management of the partnership. All partners are agents of the partnership if there is no managing partner or partners, and any one of them may bind the partnership. In case of the decision of a partner is objected by another partner, it shall be decided by the partners through a majority vote. In case of tie, the decision of partners owning the controlling interest shall prevail. However, no partner may make important alterations in the immovable property of partnership without the consent of others. In case the other partner's refusal of consent is manifestly prejudicial to partnership interests, the court's intervention may be sought. A managing partner appointed in articles of partnership can execute all acts of administration despite the opposition of other partners, unless he should act in bad faith. His power is irrevocable without just cause, and for the revocation of his power, the vote of the partners owning the controlling interest shall be necessary. A managing partner appointed after the establishment of the partnership may be removed anytime without or with just cause. When there are 2 or more managing partners, without specification of their respective duties or without stipulation that one of them shall not act without the consent of all others, each one may separately execute all acts of administration. If any of them should oppose the act of others, the decision of the majority shall prevail. In case of tie, the matter shall be decided by the partners owning controlling interests. If it has been stipulated that one of the managing partners shall act without the consent of the other, the concurrence of all shall be necessary for the validity of the acts, and the absence of disability of any one of them cannot be alleged unless there is imminent danger of grave or irreparable injury to the partnership. Examples. The managing partners of a partnership are A, B, C, and D. It has been stipulated that no one shall act without consent of the others. A, B, and C would like to obtain a loan from a bank to increase their operating capital. However, D is abroad and his consent cannot be obtained. In this case, the plan of A, B, and C cannot be implemented because of the absence of D. In the above example, if the plan of A, B, and C is to transfer all the goods of the partnership to a private warehouse while the roof of their own warehouse is being repaired, in order to prevent damage that may be caused by coming rainy season, the said plan can be implemented without the consent of D, who is abroad, because the purpose is to prevent grave and irreparable injury to the partnership.